What is the difference between an O and a P?
So an O1 is for individuals of extraordinary ability. So you have to meet three of these eight regulatory criteria showing that to prove that you are an individual of extraordinary ability. Examples of those criteria are you've made a higher than average salary, or you've been written about in the media, you've worked for organizations that are extremely well known. Whereas a P1 is strictly for athletes. There are a couple different types of P1s. One is professional, called a professional athlete, where if you're simply signed to a team that plays in a league that generates more than $10 million, you just kind of automatically get the visa. Good examples are like NBA, MLB. Those
Yeah.
leagues clearly generate more than 10 million a year. Um, but esports is so new, um, and so even though many of the leagues that I work with are generating more than 10 million a year, USCIS has actually come back in recent months saying we actually don't believe the financial statement you submitted. Um, so this application doesn't qualify for professional athlete status, which has forced me to focus on a second category of P1, which is called internationally recognized athlete. And it's kind of similar to the O1, where you have to meet two of seven regulatory criteria, some of them being you have a letter from an official of your leagues saying, this person is internationally recognized, or you've been written about in the sports media, or you've competed on a national team in an international competition. Um, and those criteria readily apply to esports players. So I've been relying more and more on internationally recognized athlete than professional athlete.
Do you need that statement for a P that you need for an O from like a union in the US? You need that for P's as well?
Yes, absolutely. So P1s do require a consultation letter from a US labor organization or professional association if one is in existence. Um, Interestingly, there are not, again, esports is so new, players have not really had the wherewithal to create professional associations or labor unions. There are a few in existence, and I do have a good relationship with them, and I can say like, hey, can you please sign this letter saying that you don't object to this player, playing in the United States. But in cases where there is no labor union, I will, submit evidence that there's no organization or U.S. labor organization um, that will sign off on a consultation letter and check the box on the form that says, no, there's no labor org, so a consultation letter is not applicable.
How have you been getting pushback from USCIS about that?
Of course, of course. Um, I would say 9 months ago, it wasn't a problem. Starting about 3 months ago, um, they will push back and say, no, a consultation letter is required. Um, and while I will cite the regulation saying a consultation letter is not required in cases where there's no labor organization, um, just to act in my client's best interest, I'll go get a letter from like a recognized expert in the field that will serve as a consultation letter.
Interesting.